The recent confirmation hearing of 10th Circuit Judge and now Justice Neil Gorsuch underscored the partisanship and polarization that exist in the United States Senate and the infirmities that plague the judicial nomination process. Indeed, although the United States Constitution provides that the President of the United States can only appoint judges to the federal bench with the Senate's advice and consent, this process has rapidly devolved into a political soap opera in which a judicial nominee's personal life and professional career, particularly his or her ideology, engender intense and often unreasonable scrutiny. The nomination process of Justice Gorsuch was no different, and the Senate's Judiciary Committee's members peppered Gorsuch with questions focusing almost exclusively on the outcomes that he reached in specific cases. For example, in moments reminiscent of the failed confirmation in 1988 of late judge and Yale law professor Robert Bork, some senators accused Justice Gorsuch of rendering decisions that were insensitive to women's and employees' rights and biased in favor of corporate interests. Such allegations, however, rather than representing a principled inquiry into Justice Gorsuch's judicial temperament and fitness to serve on the nation's highest court, reflected nothing more than an attempt to disqualify a judge who did not share their personal policy predilections. That, in a nutshell, is the problem that continues to eviscerate the integrity of the nomination process and undermine the public's faith in the fairness of political institutions. Indeed, contrary to the political theater that was on full display in the latest confirmation process, judges are not political actors, and their duty is to interpret the Constitution, statutes, and common law, irrespective of the desirability of a particular outcome or subjective policy, legislation, or preference. At its core, judging is an endeavor involving interpretation and construction, and the focus, therefore, should not be focused primarily on the outcome that the judge reaches, but on the process by which that outcome is reached. In fact, during Justice Gorsuch's confirmation process, lurking beneath the Judiciary Committee's predominant focus on outcomes was a philosophical and jurisprudential debate that continues to divide politicians, jurists, and the public regarding constitutional interpretation. Specifically, how should the language of the United States Constitution, particularly the Bill of Rights, be interpreted? Additionally, how should judges interpret the Constitution when the provision at issue, such as the First Amendment, is ambiguous and susceptible to alternative constructions? And should a judge's interpretive paradigm be influenced by the purposes underlying a particular provision, the expectation of the founders when drafting such a provision, or the historical record at the time of its adoption? Finally, should a judge's approach to constitutional interpretation consider the fairness and the desirability of the outcome, and if so, to what extent? These questions, and the answers thereto, lie at the core of the debate and cultural divide between the two predominant theories of interpretation in American constitutional law: originalism and living constitutionalism. This presentation provides an overview of both theories, explains how the application of the theories has impacted constitutional construction and meaning, and examines whether based on history, tradition, and democratic principles, originalism or living constitutionalism should be the preferred method of constitutional interpretation. In so doing, this presentation concludes that both theories should remain prevalent in constitutional interpretation, and that originalism and living constitutionalism are not necessarily incompatible. Rather, reliance upon either theory should be predicated on, among other things, whether the provision at issue is ambiguous and thus subject to reasonable alternative interpretations, whether the Constitution is silent on an issue, and upon whether the application of either theory would safeguard the bedrock principles of democratic governance. Originalism and living constitutionalism constitute the primary theories of constitutional interpretation. Originalism has many variations, but at its core, originalists believe that the Constitution's language should be interpreted based on what the founders understood the words to mean at the time that the Constitution was adopted. Conversely, living constitutionalists believe that the Constitution's language changes over time to reflect contemporary societal values and to resolve issues that the founders could not foresee, including those affecting civil rights and liberties. The appropriateness of applying either theory, however, depends on the language of the constitutional provision at issue, whether the text is ambiguous or unambiguous, and on whether the Constitution is silent on a particular issue. If the language of a particular constitutional provision is unambiguous, originalism provides the best framework with which to resolve the legal question. For example, the 14th Amendment of the Constitution provides as follows: "No person shall be deprived of life, liberty, or property without due process of law." When construing the 14th Amendment, there can be little doubt regarding its meaning. The framers intended that no citizen should be subjected to criminal penalties, including death, life imprisonment, or property forfeiture, unless the state provides adequate procedural safeguards to prevent the arbitrary imposition of criminal sanctions. Simply stated, the purposes underlying the 14th Amendment are to protect against the unjust and unfair deprivation of individual liberty. Thus, an originalist approach to interpreting this provision is preferable because it comports with the 14th Amendment's text and underlying purpose. In Mathews versus Eldridge, for example, the United States Supreme Court confirmed this interpretation and established a three-pronged framework for determining the adequacy of procedural safeguards in criminal and administrative proceedings. However, in the late 20th century, the court began to expand its interpretation of the 14th Amendment and adopt a more living constitution approach. For example, in Griswold versus Connecticut, the court relied on the 14th Amendment to invalidate a state law that banned use of contraception. In so doing, the court held that although the 14th Amendment's text did not expressly support the court's decision, the Bill of Rights contains invisible penumbras and emanations from those guarantees that help give them life and substance. Similarly, in Roe versus Wade, the court held that the word liberty in the 14th Amendment conferred a substantive and implicit right to privacy that encompassed freedom to access pre-viability abortions. In Planned Parenthood versus Casey, the court reaffirmed Roe and held that the 14th Amendment protects an individual's substantive right to define one's own concept of existence and of the mysteries of human life. Likewise, in Lawrence versus Texas, the court held that the 14th Amendment protects a substantive right to liberty in its spatial and most transcendent dimensions, and thus justified the invalidation of laws that banned same-sex sodomy. Finally, in Obergefell versus Hodges, the court held that the 14th Amendment contained a substantive right to equal dignity under the law, and thus supported the recognition of same-sex couples' right to marry. In circumstances where the Constitution is ambiguous, originalism fails to provide adequate answers to vexing legal questions, and living constitution can have a more prominent role in constitutional interpretation. For example, consider the text of the First Amendment, which governs, among other things, freedom of speech. Congress shall make no law abridging the freedom of speech or of the press. Undoubtedly, unlike the 14th Amendment, the First Amendment is phrased in broad terms and therefore requires judges to interpret the text and create constitutional meaning based on facts and legal issues presented in a particular case. For example, does the word speech refer only to verbal utterances, or does it encompass nonverbal yet expressive conduct? Similarly, what does it mean to abridge the freedom of speech? Does it mean that Congress can place no limits whatsoever on an individual's right to speak freely? Or does it permit Congress to place reasonable limits on speech if countervailing interests, such as public safety or the integrity of the political process, justify such a restriction? And are some categories of speech simply deserving of no protection at all? Likewise, does freedom of speech apply only to individuals or to corporations as well? Indeed, because the answers to these questions cannot be found merely by examining the text, originalism itself is an insufficient method by which to interpret the First Amendment and clarify its meaning. In this situation, living constitutionalism can and should play a more decisive role by considering the purposes underlying the First Amendment creating a robust marketplace of ideas that welcomes popular and unpopular or even offensive ideas, and the effects of a particular decision on principles such as democratic self-governance, the rights of individuals and states, and judicial restraint. Put differently, in situations where the Constitution's text is ambiguous, living constitutionalism can and should guide the court's interpretive approach for the purposes of reaching a result that enhances democracy, liberty, and autonomy. Similarly, the Eighth Amendment provides in relevant part as follows. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Like the First Amendment, the Eighth Amendment is written in broad terms and susceptible to alternative interpretations. For example, judges may disagree concerning whether a punishment is cruel or unusual, and an examination of the Eighth Amendment's underlying purpose, to prevent the unnecessary infliction of punishment, is invariably necessary to assist judges in arriving at a reasonable interpretation. Importantly, however, like the First Amendment, the Eighth Amendment's purpose is itself broad and thus susceptible to interpretations. In such situations, living constitutionalism can provide the courts with a framework in which to read outcomes that further bedrock constitutional principles, such as liberty, equality, and fundamental fairness, that are consistent with the amendment's purpose and ensure the legitimacy of the process by which that outcome is reached. In many cases, the Constitution is silent on a particular issue, and thus neither its language nor underlying purposes can provide dispositive answers to contemporary legal issues. In such situations, courts must consider whether they should afford deference to laws enacted by coordinate branches of governments or by state governments for the purposes of ensuring that the judiciary does not transgress the limits on its Article III reviewing authority and reach decisions that encroach on the lawmaking powers of the legislative branch. In other words, when the Constitution is silent, principles of judicial restraint and respect for the democratic process counsel in favor of deferring to the judgments made by the citizens' elected representatives. In conclusion, the confirmation process of Justice Gorsuch underscored the sharp divide that exists between originalism and living constitutionalism. However, as this presentation demonstrates, these approaches to constitutional interpretation should not be viewed in all cases as competing or irreconcilable. Instead, the utility of either theory should depend on the specific provision at issue and on whether the application of either theory would further democracy's foundational principles of citizen participation, political equality, decentralization, separation of powers, and individual and collective autonomy.